Thank you for attending Prosecuting Cannabis, Approaches from States Without Legalization, hosted by the Drug Enforcement and Policy Center, the Ohio State University Moritz College of Law, and the Prosecutors and Politics Project at the UNC School of Law. Before we begin, we have just a few notes we'd like to share with you. First, we want to draw your attention to the Q&A function at the bottom of the Zoom window. The chat is disabled, but you may submit questions at any time. Please note, however, that there is limited time available for Q&A during the webinar. Second, closed captioning has been enabled for this event. To change how you view the transcription or to hide it, click Show Caption in the menu at the bottom of your Zoom window. Finally, this event is being recorded. The recording will be made available on the event page and social media channels as soon as possible after the event. Follow us at OSU Law DEPC to stay up to date on our research, programming, and future events. Thank you again for joining us, and we hope you enjoy the event. Carissa?
Great. Thank you very much, everyone. My name is Carissa Hessick. I'm the director of the Prosecutors and Politics Project at the University of North Carolina, where I'm also a law professor. Very excited for this event today, collaboration between the Prosecutors and Politics Project and the Drug Enforcement and Policy Center at Ohio State, at The Ohio State University. Today, we are going to be presenting the results of a study that the two organizations collaborated on. And then we're also very lucky, we'll be joined by Mr. Ryan Mears, who's the prosecuting attorney, the elected prosecuting attorney in Marion County, Indiana, which includes Indianapolis. And we also have an all-star panel of academic experts here to talk with us about today's topic, which is prosecuting cannabis, approaches from states without legalization. We're going to start today's event from by hearing from Amy Ullrick, who is the project manager at the Prosecutors and Politics Project. Amy's created a really great overview of the study findings that will both help tell everyone here at today's event what we found, but also help set the table for the discussion. So Amy, if you'll take it away, please.
Thank you very much, Carissa, and thank you to everyone out there for dedicating your time to this important conversation. I'm going to go ahead and start sharing my screen with you. Okay, there you go. And again, this research, Enforcing Marijuana Prohibitions, Prosecutorial Policy in 4 States, was a collaboration between the Drug Enforcement and Policy Center and the Prosecutors and Politics Project. Now, our research question had 2 parts. The first asked about the policies and platforms of candidates for local prosecutor with respect to the enforcement of marijuana possession. And the second asked about the candidates' views on marijuana, the candidates' views on marijuana possession enforcement and public safety. So in other words, how the candidates thought enforcement impacted public safety. So to answer this question, we proceeded in 3 phases. First, we identified all candidates who ran for the office of local prosecutor in our 4 subject states, which were Indiana, North Carolina, Tennessee, and Texas. And these states were chosen because they held an election in 2022 and because personal possession of marijuana remains a crime. So next, we searched print media and Facebook for publicly available information about the candidates' policies in the first 5 months of 2022. And we chose print media and Facebook on the theory that they would be popular sources of information for voters attempting to learn about the candidates. And when we found a news article or post, we would code it to capture the type of policy articulated, or if there was any policy articulated at all. And finally, in the 3rd phase, we surveyed the candidates directly using Qualtrics, and candidates were contacted and invited to participate via email, phone, or both. And our study produced 6 key findings. So I'm going to go over those here. First, very few incumbent and non-incumbent candidates have adopted policies or platforms of full or ordinary enforcement. And I will get to how we define full or ordinary enforcement and its opposite, less than full or ordinary enforcement, in just a few minutes. But for now, think of full and ordinary as the law being applied as usual or as written. So second, practical concerns drove the adoption of less than full or ordinary enforcement policies. Third, policies or platforms of less than full enforcement could be found across political parties in both urban and rural jurisdictions, but Democratic candidates were most likely to indicate that they held policies of less than ordinary enforcement. Fourth, incumbents are more likely to believe that marijuana enforcement promotes public safety, while incumbents are more likely to view enforcement as detrimental to public safety. Fifth, non-incumbent candidates were more likely to believe their voters favored decriminalization. And last, very little public information is available on marijuana possession enforcement policies. Now, before I dive into the data behind these key findings, I'm going to tell you a little bit about the subjects of our study. So overall, we identified 289 candidates for prosecutor in our subject states, and the majority of these, or 62%, were incumbents. The remainder were non-incumbents. And while all of these candidates were invited to participate in the survey, we received responses to large portions of the survey from just over a fifth, or 62 candidates. And this group was spread throughout our subject states and hailed from districts of varied population, and were generally representative of the entire candidate pool on several important factors, including the distribution of incumbents to non-incumbents. And incumbents specifically had similar percentages of running in contested elections and winning their elections as in the overall candidate pool. The contestation rates and win rates for non-incumbents were also similar, with slightly higher percentages of non-incumbent survey respondents running in contested elections or losing their election. Now, these 62 survey respondents did not respond to each survey question at the same rate, so there's some variation in the response levels for the results I will be sharing. But for the results we'll share on what the policy or platform on enforcement was, we have 78 responses, which we got by combining our survey and media source data. And in this group, the contestation rate goes up relative to the pool of 289 candidates, which is not surprising, as many of the candidates were likely to be in the news or on Facebook because they were facing contested elections. So let's get to the survey data. The survey first asked candidates whether they had a formal or informal policy or platform on charging adult personal possession of marijuana cases. And overall, only 14% of incumbents and less than a quarter of non-incumbents indicated they had a policy on this topic. An additional 17% of incumbents and 7% of non-incumbents said that they had an informal policy. Now, whether they had a formal or informal policy, the candidates were asked to describe it, and they were given several possible descriptions reproduced in this table, as well as the option to indicate that their policy was not included on the list. So 1/10 of incumbents and nearly a quarter of non-incumbents said that their office did not or would not, if elected, prosecute any personal possession of marijuana cases. 3% of incumbents and 21% of non-incumbents said they relied or would rely on diversion rather than criminal charges for any personal possession case. And diversion for first-time offenders was the policy selected by over 1/4 of incumbents and 5% of non-incumbents. And 13% of incumbents and 18% of non-incumbents indicated that they assigned a lower priority to possession cases, but still prosecuted in some circumstances. Now, full enforcement was identified by only 5% of incumbents and 5% of non-incumbents. And treating personal possession cases no differently than other cases, so assessing them on a case-by-case basis, was selected by 23% of incumbents and 15% of non-incumbents. Finally, the last category, other, was selected by over 1/5 of incumbents and 15% of non-incumbents. And these responses varied widely. Several respondents articulated a policy of not prosecuting up to a certain weight. Several others indicated policies of deferred prosecution, but with the criminal charges involved. Now, the responses from this table can be roughly grouped into a category of, here's the definition, less than full or ordinary enforcement. This is indicated in the darker blue. So these are the non-prosecution, the diversion, the lower priority policies, and then the category of full or ordinary enforcement indicated in the light blue. So fully enforcing the law or assessing on a case-by-case basis. And when grouped into these categories, a slight distinction emerges between the policies of incumbents and non-incumbents. Non-incumbents are more likely to adopt platforms of less than full or ordinary enforcement compared to incumbents, but many incumbents also adopted these policies, as you can see, over half did. But incumbency status was not the only characteristic related to enforcement policies. Democrats were far more likely to have policies or platforms of less than full or ordinary enforcement than Republicans, 87% compared to 41%. And less than a tenth of Democratic candidates had policies of full or ordinary enforcement compared to a third of Republican candidates. But the Republicans' approaches were more varied, but a plurality, 41%, did adopt the policy of less than full or ordinary enforcement. Now, in terms of population, there was no easily discernible pattern. Approximately half of all candidates in the smallest and largest jurisdictions had policies of less than full or ordinary enforcement. But once you jumped to districts with populations between 250,000 and 1 million people, 90% had the less than full or ordinary enforcement policies. So the survey then asked the candidates who had adopted policies of the less than full or ordinary enforcement to identify the reasons behind these policies. And respondents were given several options from which they could select all that applied. Now, incumbents in the red framed their top motivation in practical terms. That is, it was difficult to distinguish between legal hemp and illegal cannabis. And as one incumbent in Tennessee put it, we've not really been prosecuting that for the last couple of years due to issues of trying to determine what's marijuana and what's hemp. Now, perhaps because the candidates were able to identify multiple reasons for their policies, there was a lot of overlap between incumbents and non-incumbents in their answers. The idea that marijuana is just not a priority, as like the hemp issue, were popular answers for both groups, as was the idea of insufficient resources. And that resource motivation was framed by one incumbent in Texas by saying, a joint costs maybe $5, but our county's taxpayers spend $20,000 every time we prosecute someone for that $5 joint. Now, notably, few respondents identified the feelings of voters who oppose prosecution or racial inequality concerns as reasons motivating their policies. Now, we only asked the candidates who had identified the less than full or ordinary enforcement policy about their motivations, but some indication of the reasons behind ordinary or full enforcement appeared from media searches and open-ended survey questions. For example, one incumbent in Indiana stated, discretion occurs on a case-by-case basis from a potential arrest all the way to the prosecutor's office. Another survey respondent said, I don't think that it's appropriate for me as the DA to say I'm not going to prosecute a crime that has been set by law. A third respondent expressed similar sentiments stating, so long as it's on the books and I'm the DA, it's going to be enforced. Now, because these candidates were running in an election, our survey sought to identify not only their policies and platforms, but whether voters had access to that information prior to the election. And what we found is that 24% of the candidates had no print media reference between January and May of last year, despite the fact that they were on the ballot in an election year. Now, 9% of candidates had an identifiable policy on print news media, and an additional 1% of candidates had a policy available on Facebook. So to supplement this small amount of information, we asked candidates in our survey whether their office or campaign had publicly announced their policy on marijuana possession. And we found that incumbents were far less likely to report that they had publicly announced, the 19% versus 52% of non-incumbents. And as a follow-up question to whether they had publicly announced, we asked why they had decided to announce or not announce. And on that question, both incumbents and non-incumbents agreed that the top reason to share the policy was that it was important or simply that someone asked. And among the top reasons both groups indicated to not share were that no policies of any kind were announced publicly or that no one asked. But additional reasons also included that taking a case-by-case approach would preclude an announcement of doing so, or that publicly announcing a policy could lead to misunderstanding. So next, we asked about public safety impacts, and candidates were presented with a series of statements reproduced in this table about marijuana and public safety. And they're asked to express agreement or disagreement with the statements from a 1 to 5 scale, strongly agree to strongly disagree. And 3 statements indicated ways in which enforcement makes communities safer. And they were because marijuana users often commit other crimes, because enforcement disrupts drug trafficking, which can lead to violence and other public safety harms, or because enforcement allows law enforcement to apprehend suspects involved in other crimes. One statement indicated that marijuana enforcement had no effect on public safety, and 3 additional statements described ways in which enforcement can harm public safety. So by diverting law enforcement and resources away from more serious crimes, by damaging community trust in law enforcement and prosecutors, or by saddling more people with a criminal record, impacting their ability to remain law-abiding. Now, the color-coded responses are meant to indicate high levels of agreement in green, low levels of agreement in red, and relatively even splits in yellow. And as the table illustrates, non-incumbents were more likely to think that enforcing marijuana laws had either no effect or negative effect on public safety. So for each of these statements, more than half of all responding non-incumbent candidates agreed, compared to less than a third of responding incumbents. Now, incumbents, on the other hand, were more likely to agree with the statements, in statements claiming that enforcement increased public safety, some as high as 81%, when it came to helping law enforcement apprehend suspects involved in other crimes. But 45% of non-incumbents also agreed with that statement, and half agreed with the statement that enforcement can make communities safer because of the disruption to drug trafficking and its effects. So shifting gears a bit, the survey also asked candidates whether they believed the majority of voters in their district supported or opposed decriminalization. And 9% of incumbents believe voters supported decriminalization compared to 59% of non-incumbents. Half of incumbents and almost a third of non-incumbents believe voters opposed decriminalization, and 41% and 9% of both groups were not sure about the beliefs of voters in their districts. Now, there was some agreement between the candidates' opinions on voters' beliefs and the candidates' own policies. So 87% of the respondents who believe that voters supported decriminalization had also adopted a policy of less than full enforcement, while 7% still maintain that full or ordinary enforcement policy. And of the respondents with a policy of full or ordinary enforcement, 82% of those candidates believed voters opposed decriminalization, while 9% actually thought the voters favored decriminalization. So the survey also asked the candidates if they had made public statements in support or opposition to state legislative efforts to decriminalize marijuana for adult personal use. And the vast majority, 91% of incumbents and the majority of non-incumbents had taken no position. That's these gray bars. Now the blue represents the 9% of incumbents and close to a third of non-incumbents who said they expressed public support for decriminalization. And the red, the 9%, are non-incumbents who publicly opposed decriminalization. Now, of the candidates who had taken no position, 62% had a policy or platform of less than full or ordinary enforcement. And so perhaps prosecutors believe they have discretion to adopt policies that do not fully enforce the laws as written, even without legislative change. It's also possible that candidates did not publicly support decriminalization efforts because they didn't think it was important in elections. And when we asked how important local policies on marijuana possession enforcement had been in their election on a scale of 1 to 5, 5 being very important, 1 being not important at all, the respondents overwhelmingly answered that it was not an important issue for voters. A combined 82% of incumbents and 57% of non-incumbents felt it was either not at all important or not very important in their election. Only 5% of incumbents and just over a third of non-incumbents felt that it was either somewhat important or very important, although very few in the very important category. And finally, as it was an election year, we were able to determine whether the candidates who had adopted different policies had won their election. And for incumbents, it appears that enforcement policies were not related to winning the election or winning re-election. Barely any incumbents who responded to the survey ended up losing their election. And the few incumbents who did lose lost at similar rates across enforcement categories. Now, the relationship looks somewhat different for non-incumbents. Those candidates with a platform of less than full or ordinary enforcement won at a lower rate than those with platforms of full or ordinary enforcement. But there is reason to doubt that these policies played a big role in election outcomes because so many candidates did not publicly announce their platforms. It's unlikely that the issue drove voter decisions. And again, the candidates themselves did not perceive the issue to be an important one in the election. So the big takeaway is that when it comes to enforcing marijuana possession laws, limited enforcement policies are actually quite common, and that these policies and platforms go unannounced is a bit troubling, not only because it reduces the ability of voters to cast informed ballots, but it can affect public perceptions about prosecutorial power and the realities of marijuana enforcement laws. And with that, I'm going to turn it back over to Carissa.
Great. Thank you so much, Amy. I really appreciate that overview of the study and the findings. At this point, I'm going to introduce the first of our panelists, Mr. Ryan Mears. Mr. Mears is the prosecuting attorney in Marion County, Indiana, which includes, among other places, the large city of Indianapolis. Mr. Mears, thank you so much for joining us today.
Thank you very much for having me.
I'd like to ask you a question about something that happened soon after you were appointed prosecuting attorney in Marion County in 2019. So soon after that appointment happened, you made a public announcement that your office would no longer criminally prosecute possession of 1 ounce or less of marijuana. Would you please describe to us the reasoning behind that decision?
Well, my background is a rank and file prosecutor. I've been a deputy prosecutor for 15 years. And when you're involved in the criminal justice system, you cannot help but recognize that there's inequality that exists in our system, in particular as it relates to drug enforcement. And I cannot tell you how many times I went into courts and I saw people being prosecuted for possession of marijuana, and it didn't really reflect who was actually using marijuana in our community. And so I'm a big believer that if we see these types of injustices occurring in our community, and we're fortunate enough to have one of these positions, it's really important for us to stand up for what is right and say we're not going to continue to perpetuate these types of injustices. And I wanted to start my term off by making that position very well known, so people would understand what we were trying to accomplish at the Marion County Prosecutor's Office, which is hopefully justice.
Wonderful. Now, You were appointed in 2019, and this past fall, the fall of 2020, you faced what, to me at least, reading the media coverage, looked like a pretty bitter election. You had a very well-funded Republican opponent in the general election. There was a lot of public criticism from law enforcement in your area. In the election, there were comments made by people about rising crime rates and concerns about public safety. How, if at all, did those attacks and those criticisms affect how you talked about marijuana and other policies that your office had that were designed to achieve justice?
Well, I think the biggest thing for us is we wanted to send a message to the community that we're going to focus on violent crime. And certainly we saw an increase in violent crime as many metropolitan areas did. But that's where our focus was going to be. And if everything's a priority, nothing's a priority. And if we're going to devote resources to, a $5 joint, that's taking away time, money, energy, and effort that we could be putting into more serious and more violent crimes. I think the other part of it is, we really were in a position here in Marion County, especially where law enforcement didn't solve a lot of crimes because there was no trust between law enforcement and the community. And one of the ways to help build that trust and establish that trust is to go into the community and say, I'm not interested in trying to jam you up on this small possession of marijuana. What I am interested in is solving the individuals who are dramatically impacting your quality of life because they're being involved in violent crime. And that's a very powerful message that I think people in the community appreciated.
So I want to go back for a minute to the idea that you decided to announce the policy, because as I'm sure you heard the description of what we found that you certainly weren't alone in the prosecutors that we surveyed in saying that they weren't going to fully enforce marijuana laws, right? Adopting some sort of policy. So yours was an ounce or less, and there were other similar policies. But so many of them decided not to announce those policies. I was curious if you could say just a little bit more about why it is you wanted to publicly announce it, and if you could speculate for us maybe about why it is that other offices don't seem to take the same approach. There's not a lot out there where elected prosecutors explain what their enforcement policies are.
Well, I think the first part of it goes back to that issue of trust. There's a lack of trust between certain communities and law enforcement and the criminal justice system. And a lot of that lack of trust stems from the war on drugs and seeing how people were disproportionately treated by the criminal justice system. And so if I'm going to have any credibility in the community, I need to be very forthright and honest about what we're doing as it relates to drug crimes. And so it was important for me to send that message that we're not going to mess around with possession of marijuana. We're not going to continue to see this racial disparity that exists as it relates to who's going to be prosecuted, because it's important to me that the community understands where I'm coming from as it relates to those issues of racial justice. I think the second part of it for me too is I have an obligation to tell the community how I'm going to spend my money, how I'm going to use our resources. And I don't think it's an appropriate use of resources to waste this money on possession of marijuana prosecutions. What I do think is appropriate is to focus on violent crime and make sure we're using the power of the prosecutor's office to try to help people. So I think those are why I was very aggressive, frankly, and kind of letting people know where I stand, because it was a bit about an issue of trust and also how we're going to use our resources. The reason people don't do it is you get criticized and you get a lot of heat from law enforcement, and law enforcement does a lot to try to undermine what you're trying to do. So I mean, it's very much the path of least resistance to just kind of quietly divert everything or quietly dismiss everything, as opposed to just come out and say what you're doing, because you don't attract nearly as much attention from law enforcement. And in particular, we have a very engaged police union who has a lot of comments and a lot of things to say about what they think should be done. And I probably could have made my life a little bit easier had I, just kept it to myself. But that's not what the community needed. What the community needed to know is where our priorities were going to be. And also we needed to help reestablish that trust. And if we're able to build that trust, we're going to solve more crimes and be in a better position to help more people in our community. And that's why we were so public with our position.
That's really helpful. I just want to remind our audience that there's a Q&A sort of button below the screen. You should feel free to enter your questions now, and I'm going to leave some time at the end of the event to make sure that we get to audience questions. But before we do that, Mr. Mears, I have one more question for you. And that's, you've talked a bit today about the relationship between marijuana and public safety. And you were not sort of your answers don't seem to resemble, I would say, sort of the typical incumbent, because you've expressed the feeling here today that enforcing marijuana laws or aggressively enforcing marijuana laws can undermine trust in the community and thus, you know, have a detrimental impact on public safety. We seemed to get the opposite response. As I'm sure you saw in Amy's presentation, incumbents were far more likely to say that enforcing marijuana laws would promote public safety, and it was non-incumbents, right? Folks running for open seats or folks who were running as challengers who took the position that you were taking, that actually enforcing these laws could undermine public safety. Why do you think it is that there's such a sort of stark contrast between the views of incumbents and the views of non-incumbents? Could you say a little bit more about that? And then I may ask you another question actually to follow up on it.
Well, I mean, incumbents typically are interested in protecting the status quo and the path of least resistance, maintaining the status quo. And if you're just going to sit around and tell law enforcement and everybody else that, hey, you guys are doing a great job, don't worry about it, you're not going to get a lot of attention. You're not going to get a lot of heat. And I think that's why incumbents so oftentimes are okay with the way things are going. You know, my background is I'm not a politician by trade. I became the elected prosecutor because I actually did the work. And so I feel like I had a different perspective. And so, you know, I always felt like, hey, if I was fortunate enough to get this position, I need to be more aggressive and make sure that we are righting these wrongs as opposed to just trying to maintain the status quo. And I think a lot of incumbents are more concerned about maintaining the status quo and making sure things are, you know, it's kind of smooth sailing, as opposed to maybe being a little bit more disruptive or more willing to tell people that the criminal justice system needs to change.
And to follow up, that's a very helpful answer. To follow up on that, so do you see this more as a question of status quo versus non-status quo? Or do you see it instead as maybe there are certain views about law and order and how to achieve public safety that maybe go along with status quo? Or is it something else besides status quo bias? You know, an academic would say the status quo bias.
Yeah, I mean, I think it's a little bit of everything. I mean, you know, once you are in this position, you work with law enforcement every day, and then to tell them, hey, we're not doing that anymore, you're going to get pushback. And a lot of people don't like those. Those are uncomfortable conversations, and they're going to be unpopular conversations amongst law enforcement. And so there's a lot of people who just don't want to have those conversations and don't want to deal with those issues. And I think that plays a really big part of it as well. I think people sometimes lose sight of the fact that you're elected by the community and you serve the community doesn't serve you, and your job is not to serve law enforcement. And so you need to put the needs of the community ahead of those of maybe what people in law enforcement think about positions like not prosecuting possession of marijuana. And sometimes I think that can be a challenge for people, in particular when they have to have close working relationships with those departments and agencies on so many cases.
Wonderful. Thank you so much. So, Mr. Mears, I'm gonna ask you to hang out with us a little bit longer as we bring in our academics, because I know it's popping up on my screen that we have a lot of questions for you. So if you wouldn't mind sticking around for a little bit, we'll bring in the law professor group, and then we'll open it up to audience questions.
No problem.
Great. So if the law professor panel could please join me now. I'm very excited by this lineup. We have three distinguished academic experts. We have Professor Sam Kamen, who's on the faculty at the University of Denver. We have Professor Lauren Uziel, who's on the faculty at Temple University. And then we have Professor Zachary Price, who's on the faculty at UC Law San Francisco. Thank you guys all for joining me. It's very nice to see you today. So I have the same questions for each of you guys. And I think sometimes you guys might agree with each other. Sometimes you might disagree a little bit. And sometimes I think you might disagree a lot. So rather than going sort of one after the other, I'm just going to ask them and ask you guys all to sort of jump in and start answering. So the first question that I have for you is, as you could tell from the presentation, our study looked at enforcement policies associated with marijuana possession. And we found that a lot of prosecutors are not enforcing those laws as written, right? Some of them are sending cases to diversion. Some of them are treating first-time offenders more leniently. Some are just deprioritizing these cases as compared to others. And then some just aren't enforcing these laws at all. So based on what you know, both from your professional experience and then also from your academic expertise, do you think that these sort of limited or under enforcement policies are common for other types of crimes as well? And why or why not?
Great. I'm happy to start, Carissa, and thanks for the invitation to all the organizers for putting this together today. I think the short answer to your question is no. I'm not shocked that there is less than full enforcement of marijuana laws. I think there's probably less than full enforcement of all laws. That police don't fully enforce all the offenses that they see. Prosecutors don't seek to prosecute all the cases that police officers bring to them. I think the real question that we're asking when we talk about discretion and drug enforcement, particularly minor drug enforcement, as you surveyed, is how much under enforcement. That is, sort of you talked about various ways of categorizing that, whether it's I won't enforce those laws, or those are a low priority for our office, or yes, we'll try and divert as many of those as we can. Those are all different ways that prosecutors exercise the discretion. But the discretion that you've identified and categorized here, I think, is a really common and I would say necessary feature of any criminal justice system, the size of which we're talking about in the United States.
Yeah, I agree with that. Many laws are what we would call in sort of a broad way under enforced, but I think it might be useful to think about the different categories of under enforcement, because I think they're actually quite distinct. So if we think about diversion, you could imagine, for instance, a very fulsome prosecutorial effort and police effort to bring those cases into the system, but then to use really a rehabilitative model, which is what diversion is. Diversion is not non-prosecution, right? It is bringing folks into the system, but using a totally different non-punitive rehabilitative approach. And I wouldn't really even characterize that as under enforcement. It's just a different mode of enforcement. Whereas declination obviously is under enforcement. And then there's the question, as Sam said, of what degree are we talking about? A categorical non-enforcement policy, as Mr. Mears had mentioned he had done in one category of case, or are we talking about sort of saying something like this is not my focus. Our office's focus is on different kinds of crimes, and sort of leaving that open, but knowing that you're not gonna prosecute quite as many cases in that category.
Yeah, I agree as well. And let me just add to the thanks for being included here. It's been really interesting. And I also thought the report was really well done and illuminated these issues in a really interesting way. I guess to pick up on what Lauren was saying, I mean, it seems to me that it's a pervasive feature of the way prosecutors' offices operate, that they can't pursue everything. They have to pick and choose. They have to set priorities. But so in some ways, the important question is how they go about doing that, how open and transparent and categorical they are. And one finding I thought was really interesting in the report is that the finding that the kind of categorical approach doesn't seem to be all that common. It's something that's really leapt to prominence with kind of self-described progressive prosecutors in a lot of jurisdictions. But I found it interesting that in other words, a lot of those prosecutors who kind of openly they'll claim credit for not enforcing laws, adopt pretty clear policies, and make it a selling point. And that's been a controversial approach that's gotten a lot of attention. But if these findings are representative, it looks like that hasn't penetrated all that deeply. It seems like more people are still doing what I would consider the more kind of mainstream approach of setting internal priorities with varying degrees of transparency, but not kind of claiming credit in that way. So those kind of more overt approach has been common in some big urban jurisdictions and gets a lot of attention, but it could be that it's not as widespread a phenomenon as you would think from how much coverage it's getting.
That's an excellent point. Yeah. Well, so let's broaden it up even further, and let's turn to the sort of thinking that academics excel at, which is the sort of even more abstract. What should we think about all of this? In particular, what should we think about prosecutors not enforcing laws as written? So Lauren, for example, has staked out the claim that diversion is not under enforcing the law. It's just taking a different approach to prosecuting cases. But should we think about maybe other types of under enforcement, setting priorities, categorical non-enforcement, sort of smaller, you might think of it in terms of smaller categorical non-enforcement, under a certain amount, first-time offenders, we don't pursue cases. How should we think about that? I mean, there's obviously, as Zach flagged, right, this is an issue that's gotten a lot of prominence, being transparent about what these policies are, a lot of talk about whether this is neglect of duty. Other people saying it's pretty mainstream to do these sorts of things. It's a way of dispensing leniency within the system. And maybe just to pile on there with one more question, do you think your answer or other people's answers to these questions might depend on what it is we're talking about, right? If we're talking about marijuana enforcement, it's pretty clear that decriminalization efforts in the legislature are lagging behind public opinion. There's quite a lot of public support to decriminalize marijuana, and it seems to get sort of caught up in representative politics. So nothing too narrow here for you guys. Zach, do you want to take this first? I feel like I have you here in part because I feel as though you spent a lot of time and many years really trying to come up with a way to think about under enforcement and non-enforcement.
Yeah, thanks. So I mean, on the question of kind of legal authority, in other words, is it appropriate or kind of neglect of duty to kind of openly, categorically not enforce laws? I think it actually depends on the law of the particular state. I think as a general matter, I think prosecutors should kind of as a default understand themselves to be bound to give effect to the laws they're charged with enforcing. And that doesn't necessarily mean seeking kind of maximum penalties, but I do think it means kind of taking the conduct rules that the legislature has established seriously. So if you think about the kind of federal context, for example, you've got a kind of unitary executive branch, right, headed by a president. Everybody in the executive branch is to some degree responsible to the president, and the president has an obligation to, as the Constitution says, take care that the laws are faithfully executed. I think that means kind of giving effect to laws, and I think it's inconsistent with that to kind of categorically suspend enforcement of some statute. So I think that generally carries over to the state context, but it's complicated by two features of state governance that are very common that depart from that model. One is states don't have a unitary executive branch in a lot of cases. They have separately elected state level officials, the attorney general, as well as the governor, for example, and what powers they have may vary. But then also most states have locally elected prosecutors, and that could create an inference that why have locally elected prosecutors? You could infer the point is to have kind of enforcement choices that are accountable to a local constituency rather than kind of statewide legislative choices. So that complicates that inference that, your job is to give effect to state laws. But the fact is states have very different structures and arrangements in terms of how those pieces all fit together. There are some states, for example, Texas, which is in your report, has very strong independence for local prosecutors, to the point that there are now kind of state level legislative efforts to dial that back because of dissatisfaction with some local non-enforcement policies. But I think with that arrangement, it's really strengthens that inference that local prosecutors are kind of meant to do their own thing to a degree. But you have other states where there's very strong top-down control, or there are provisions in state law or the state constitution that kind of emphasize the duty of enforcement. In California, the state attorney general has a constitutional duty to ensure uniform and adequate enforcement of state laws. And I think that kind of provision cuts against an inference that local prosecutors are supposed to kind of pick and choose what laws they think are important. So that's my view of the law. I will say, though, that it doesn't track the actual practice very well. It seems like instead people kind of do what they can get away with. And an interesting thing is you're seeing more and more fights along those lines as we get more kind of political conflict over criminal justice policy. And I think people should attend more to the kind of positive features of state law as a way of kind of navigating these issues in a more grounded way. But that hasn't really been the pattern so much that I've seen at this point.
Sam, could you chime in a bit, and can you talk a little bit more specifically about drug policy, since that's an area of your expertise, and the role that prosecutors have played in the war on drugs?
Sure, I'd be happy to. And the piece I was thinking I would speak, and I think I can tie it to your question, is the one about, does it matter what kind of law it is that we're talking about? That is, does it matter whether we're talking about marijuana possession, which is sort of, in some ways the definition of broken windows policing, right? That this is probably one of the most minor, at least in present day, one of the most minor offenses in the criminal code, and one that yes, can have a relationship to public safety, but doesn't have sort of a direct effect. I think if we contrast that with more serious crimes, it pushes us on some of our views about discretion and how much should be afforded to local or statewide prosecutors. So, if you imagine a prosecutor saying, I really believe that what happens in the home is between a husband and a wife, and I won't be prosecuting any sexual assault or physical assaults that take place in a domestic context. I feel very differently about that than I do about drug policy. Even as someone who studies drug policy, I would posit, and I think most people would agree, that kind of legalizing of certain otherwise criminal conduct, or conduct that the polity has agreed should be criminalized, is very different and much less legitimate than saying, my office has to make a number of fiscal decisions about which crimes we're going to proceed with, and I just don't think my constituents want me using my resources on this. Is certainly more benign for a less serious offense than it is for a more serious one. I would put somewhere in between the context of prosecutors who have announced in death penalty states that they will not be seeking the death penalty for for any homicide that occurs within their jurisdiction. When we had a death penalty in Colorado, we certainly had prosecutors who made that assertion quite publicly as part of their campaigns. I think it's quite it's somewhere in between those two situations. That is, they're not saying we're going to legalize this conduct and we're going to allow people to murder one another. They're simply saying this is a legally authorized punishment that we will never seek. And instead of doing case by case adjudication, I just don't think that's how the voters want me to spend the money. So I do think context matters, and I do think the seriousness of the offense matters. I didn't answer your question as much as I had hoped to when I started on that, but if you want to talk more about drug policy particularly, I'd be happy to do that.
Great, thank you. And Lauren, can you jump in here? I think I know that you also study like big structural things in the criminal justice system, but one thing I've always admired about your work is that it's also very practical. Like you bring a very practical bent to these more sort of theoretical questions as well. So what do you think? How should we think about under enforcement or non-enforcement?
So I think one key feature is thinking about whether it's a crime that involves a victim or not. So, obviously, in addition to sort of the changing public perceptions of the seriousness of given crimes like drug crimes, even you can imagine the movement from small amounts of marijuana possession to larger amounts to, right, all of those crimes as a category don't generally at least involve direct victims. And so you can see this starting, at least in my city in Philadelphia. There's some discussion by the district attorney about not categorical non-enforcement, but he has mentioned, here and there that, listen, when we're talking about illegal gun possession, like, people who have criminal records and can't possess guns, then again, they're living in these really dangerous communities where there's a ton of gun violence and they feel they need guns to defend themselves, right? And so these are crimes just carrying the gun without a license or without legal authorization to carry a gun. There's no victim in that specific crime. Obviously there would be if the gun was used, but that's not the crime that's being discussed. And so you can see this sort of bleeding into these areas, I think, where you have victimless crimes. I think it's easier in those cases. I don't think this would be on the table at all for crimes where there are victims, because prosecutors have pressure from victims and family members and community members that's sort of a no-go area.
Very smart. Good point. So I just want to remind people we're getting a lot of Q&A. I'm going to turn to that in just a minute, but before we do, I have one last question for our panelists, and that's as somebody who studies prosecutors as an elected office, I was really disappointed to see how few incumbent prosecutors had publicly announced their enforcement policies, right? It was less than 20% or less than 20% of them had publicly announced. And this was in an election year that we were asking. And so I worry to the extent that we think we elect local prosecutors to have some sort of local control over the important decisions that they have to make. I just don't see how the voters can serve that or, play that role if they don't know what's happening in the offices. So what are your thoughts about publicly announcing policies? And maybe my view is too simplistic. And Lauren, if you don't mind, maybe we'll start with you because you've written very thoughtfully about transparency and the lack thereof when it comes to prosecutorial decision-making.
Yeah, thanks. So I think, it's really helpful to take a historical perspective and sort of think about the changing role of the prosecutor over time. And I have written about this and really, I think that we are sort of mired in a system that's using procedures that worked when, 100 years ago, you had completely different gatekeepers of the criminal process, right? The gatekeepers were grand juries, they were judges, right, evaluating complaints and warrants for probable cause. And now it's really, we have a plea bargaining system where prosecutors are really the gatekeepers of deciding who should be charged, even where you have grand juries, that's really sort of a pro forma function. It's really the decision of the prosecutor. And yet at the same time, even though prosecutors have this discretionary power of who to charge and what crimes to charge and what crimes to focus on, there's no public visibility into that process. And that, I think, is something that really needs to change in a drastic way. And I think, I'm a little sort of disheartened about, I feel like the conversation about this transparency is always about policies. Like, are policies announced? Are they not announced? Should they be announced? And I think that announcing policies is great. It's the bare minimum. It's sort of the tip of the iceberg of what needs to be done. But I think, two things on that. First, when we talk about publicly announcing policies, it doesn't have to be a categorical policy, right? A policy could be, this is not our priority. I'm not saying I'm never enforcing these crimes, but this is not my priority. Here are my office's list of priorities in this order, kind of thing. That's announcing a public policy, even though it's not a sort of black and white one. But beyond that, I think we can think about other ways to have greater transparency into prosecutorial discretion. Public publication of declination decisions would be a great place to start. Obviously, people, non-charged persons should have privacy, but I'm talking about bulk data, which the federal system actually publishes. And there's no reason it couldn't be published at the local level by every prosecutor's office in the country. And that would also be a great way to keep tabs on whether the publicly announced policies are actually being implemented.
Great point. Great point. Zach, what are your thoughts about this? The sort of the transparency of what happens, and then the sort of the concept of prosecutors as an elected office.
Yeah, so I think I pretty much agree with Lauren. I think transparency can enable accountability, but it can also kind of impair the way institutions function. And I think it's a kind of a double-edged sword with law enforcement, because if a prosecutor can't realistically fully enforce a law, is going to be picking and choosing cases, but nonetheless is taking seriously the obligation to give the law effect, then it could be counterproductive, right, to disclose that they're not going to enforce in certain circumstances. So in this context, in other words, right, transparency enables accountability to the public about enforcement choices, but at the same time, it can enable evasion, right? So for that reason, I know in the federal context, right, when people make FOIA requests for enforcement policies, often they'll get denied on the grounds that they impair the law enforcement function. So, if it's a situation where there's a good claim that the prosecutor has the authority to kind of make categorical non-enforcement choices, then might as well do it transparently. But if you're in that environment where there's a sense they should be trying to give effect to law, so it can be counterproductive to disclose things. So I think, as Lauren was suggesting, right, one way around that is to make the policies non-committal. But I do think kind of disclosing things like declination policies is actually a more useful way of getting accountability. Shows concretely what's happening, and it enables a kind of transparency about enforcement choices, but without giving kind of an advanced signal about, it doesn't telegraph to regulated parties, right, that they can get away with certain things. Instead, it just makes clear to the public kind of, here's where we're really focusing resources.
And Sam, what do you think? And is it different when we're talking about drugs? I feel as though sometimes there's a sense that drugs, maybe because so many drug crimes don't have a victim, and because there's a sense that there's so many discretionary decisions that have to be made, should we think about these questions about transparency differently when we're talking about drugs?
Yeah, I think that's a great point, Carissa. Drugs are different in the way that's already been discussed, and that they don't have a direct victim. Though I would say what's happening in Zach's city right now sort of is the counterweight to that. A lot of the complaints about livability and sort of public safety in San Francisco have to do with open air drug markets and with people openly using and particularly openly injecting drugs, and those are, ostensibly victimless crimes or crimes that we've historically categorized as victimless. But I think if you're raising a family in San Francisco or anywhere near the Tenderloin, you see, or many people see, and many people post online about the threats to public safety, to the general well-being of these victimless crimes occurring in broad daylight and being ignored by by police, and by extension by prosecutors. That is, if a prosecutor's office worked with law enforcement to deal with that crime more directly, there would be less of it. And I think that in that way, it does reflect a decision that's made by an office, and one that has received national attention. So I would say that, yes, I agree. Generally, drugs, and particularly marijuana, and particularly possession, are seen as more amenable to declination decisions, more amenable to broad policies of non-prosecution. And it goes back, I think, to something that Mr. Mears said in the introduction, which is, if you're a challenger to an incumbent, saying, well, I will evaluate that on a case-by-case basis based on this 10-factor test, that's not very sexy, right? And that's not likely. I think he talked about generating some traction. Saying, I won't use my scarce resources on that kind of crime, is the sort of thing that does grab attention, is the sort of thing that does distinguish maybe one candidate from another. So I think that might explain some of the data that you saw in terms of who's, although I don't know quite how well it matches one-to-one to your findings. It's certainly, if you think of incumbents as status quo minded and challengers as less so, might explain the willingness of a challenger to take a firm position, to state a position and to take a firm position, as opposed to, I will make the best decisions I can under the facts of a particular case. That's what we hope prosecutors are doing. That's what I hope prosecutors are doing in the main. But as someone trying to take on an incumbent, you can imagine why they might take a different tack.
Great, thank you. Okay, so we have about 15 minutes left, and we have several questions from the audience. So I'm going to go ahead and welcome back Ryan Mears and Amy Ullrick. If you don't mind joining us again, we can go through some of these questions and see if we can give answers to some folks. So one question, and this was specifically directed at Prosecuting Attorney Mears. Someone would like to know whether, since implementing your policy, have you seen any changes in terms of the racial imbalances of who is appearing in court on criminal charges?
Yes, I would say it's a little bit. It's been incremental progress, but it has been progress nonetheless. I think what stuck out to me in terms of, when we took a look at, I think when I took office, we had 330 pending possession of marijuana cases. The overwhelming majority of those were individuals who were people of color. And it was also the overwhelming majority of those individuals, it was their first entry into the criminal justice system. And so as a result of this policy, we're keeping a lot of people out of the criminal justice system who would potentially be in there if we chose to pursue even a diversion agreement. Those individuals are still in the criminal justice system. I really appreciated Lauren's comments about that. And so, yes, we have seen progress on that issue, but it's been incremental progress. And I don't want to overstate what we've been able to achieve as it relates to that racial equity issue. But certainly eliminating these types of prosecutions have reduced the number of people in the criminal justice system, and in particular reduced the number of people of color in the criminal justice system, but not to the extent that we would like to see.
Great. The next question we have, I don't know the answer to this one. I'm kind of fascinated by it. And the question is pretty drug policy specific. So the person is asking whether we have much information on which interest groups are backing politicians who are opposed to decriminalization. And the context here is that the person's saying, I find it hard to believe that only 9% of incumbents believe that their constituents support decriminalization when national polls show in excess of 60% support for legalization, let alone decriminalization. I don't think that I know much about this, the politics of decriminalization or keeping things criminalized.
Yeah, I can speak to that a little bit. I think it's important to remember that your survey took place in places that had not legalized marijuana. So there's at least some reason to believe there's less support for it in those states than in others. Though, I think as the report indicated, there is certainly a trailing. This is a place where public policy seems to be, and particularly at the federal level, public policy is clearly trailing public policy is trailing public support. There's a saying about marijuana and legalizing marijuana, the salience of it in politics, that support for marijuana legalization is broad but shallow. That is, when you ask people, even people who are supporters of drug law reform, where it ranks among their priority issues, it rarely cracks the top 10. So it's true that you have now increasing majorities of people saying that they support marijuana legalization. It's true that you have 40 states by some count that have now legalized marijuana for some purposes. But those do not yet seem to be issues on which people are voting politicians up or down one way or the other. I think it's the reason that, notwithstanding the high support for marijuana change at the federal level, we've seen very, very slow progress in that direction. If the elected officials of the marijuana legalized states saw themselves as a voting bloc, they could do whatever they wanted in Washington. They'd have supermajorities, they could overturn any presidential veto, but clearly they don't see themselves in that way. In the way that they might with regard to other issues. So, that's one piece of it. In terms of who supports marijuana legalization, as opposed to, and I'll speak mostly to marijuana, that we could also talk about psychedelics and other things that have been increasingly the subject of initiatives around the country. There is organized opposition to legalization. I don't know how many interest groups support legalization. That is, the legalization is supported by criminal justice reformers. Has support from libertarian groups. It's not necessarily a pocketbook issue that a lot of people or a lot of large interests mobilize in favor of. Against has usually been law enforcement groups in the main. Also some drug policy opponents, people from drug treatment and other related fields. And there's been, at least in a few instances, big pharma or other people who see legalized marijuana as competition for either alcohol or pharma have come down on the anti side. So in terms of interest group politics, that's about as much insight as I can give you on that.
Interesting. And I guess just a slight variation on this question, and it's related to another question that we got, but it's a question actually about voter preferences. And I think this is both a question about marijuana, but I think it's a question more generally about local prosecutors and their constituents. So the surveys that we see are often national about support for decriminalization or legalization. Sometimes they're on the state level, but they're not usually going to be on the county level, so that an individual prosecutor would necessarily have sort of high quality polling to let him or her know what the constituents want. I guess sort of a question for prosecuting attorney Mears: how do you sort of take the temperature of your constituents to see what they support? And then maybe sort of more generally for the academics on the panel, how can we think about prosecutors representing their constituents if it's so difficult for them to maybe have access to the same information about what their constituents want? But go ahead, you first, Attorney Mears.
Well, I think the biggest thing is just making sure that you're in the community and having those constant conversations with people in the community. And, I think for us, I had a pretty good feel soon after we announced the policy, just from the overwhelming positive feedback that we received from people in the community. And so, I mean, you just can't listen to the loudest voices on either side. Are you really involved and entrenched with the community where you can get that feedback and really understand the pulse of where the community's at? And I think with this particular issue, I mean, it hit every different demographic. It hit wealthy people, it hit poor people, it hit veterans, it hit people going through medical issues, it hit people on the financial implications, it hit people on the racial disparities. And so you really were able to get a really full picture of how this issue had really directly or indirectly impacted your constituents. I think the other thing too, though, when we talk about marijuana, we also have to talk about the collateral consequences of this issue. You know, it's a way to establish trust in the community. That's really important. It is a way to kind of prioritize resources, which is important to a lot of people in the community. I don't know that there's a ton of people out there who are going to vote solely on the issue of marijuana, but they are going to vote on the issue of, do we trust the prosecutor and do we trust the direction of the office, which is directly related to your priorities and whether or not you've established that trust with the people that you serve.
Great. I have one more question. I think we have just enough time to cover it. And this question is actually drawing attention to the recent sort of spate of bills that we've seen introduced by state legislatures, and also some actions that have been taken by state level officials looking to displace the discretion of local prosecutors or even remove them. And the question whether that might also drive decisions not to speak too much about enforcement policies, right? That, you know, you might be elected by your local constituents, but you don't have this office in a vacuum. And maybe Zach, you sort of talked about this in terms of unitary executive versus, just sort of local or sort of, what's the opposite of a unitary executive? I'm not sure that I know.
Some people say unbundled or
Okay.
plural. Yes, I think it's an interesting time. I think, so just as a matter of kind of basic, kind of black letter constitutional law, I mean, municipal governments are, as a constitutional matter, kind of arms of the state and creations of the state government. So within the limits of the state constitution, legislatures do have authority to make adjustments. So I think there's not, it's a legal matter. I mean, it's just a matter of political will at the legislative level. And then, in some states, actually, the local prosecutors are kind of constitutionally autonomous or protected. So there might need to be a state level constitutional amendment. But I find the broader political story interesting. I think we had a long period, kind of often called the kind of tough on crime era, where it was sort of understood that politics push uniformly towards severity, punishment, kind of enabling kind of enforcement authorities to convict whoever they determine is blameworthy. And there's a kind of sense that the politics were a one-way ratchet. And in prosecutorial discretion was an important part of that story, because the idea was, because prosecutors have discretion, right, legislatures can enact really broad and harsh laws and then count on prosecutors not to pursue cases where the public won't consider the person blameworthy. So there's kind of incentive on legislatures to push towards breadth and severity, counting on prosecutors to make the law on the ground more reasonable. And, for a long time, kind of all the political incentives were pushing in that direction. And so you didn't get a lot of kind of state local conflict over these issues, kind of understood what prosecutors are supposed to be doing, and everyone was on the same page. But now, interestingly, and I think about the past decade, right, criminal justice has become a much more conflicted area of politics, where there really is a powerful constituency that wants criminal laws dialed back, wants less severity, less harshness. And I think it's in that context where you're starting to see conflicts at every level. And one way that plays out is, local prosecutors who have a constituency that's maybe more on the reform end coming into conflict with state level officials who maybe the statewide constituency is still more on the pro enforcement side of things. And so a lot of these, there have been these sort of dormant powers that state level officials have that now are kind of getting used more. And we're just seeing a lot of kind of areas of state law, state constitutional law come to the fore because of that underlying political conflict. But I guess the last thing there on the kind of, I think prosecutorial discretion is still, there's a kind of double-edged quality to it in that context, because you're thinking about something like public opinion on marijuana. On the one hand, like non-enforcement can give effect to that public preference within a particular jurisdiction and kind of mean that unpopular laws aren't being given force. But at the same time, if it could relieve pressure on legislators, right, to change the law itself, which might be, more desirable or more kind of an outcome with more long-term effects. So even on that level, I think the issue of how to think about enforcement discretion is complicated, because it can provide an outlet for public opinion, but it can also kind of obstruct the political pressure on more significant legislative reform.
That's an excellent point. So unfortunately, we are out of time, but I hope that everyone else enjoyed this panel as much as I did. Thank you all so much for joining us. I really appreciated the chance to speak with you. And I really enjoyed this collaboration with DEPC, and I look forward to talking to you all more in the future about prosecutors, politics, and maybe drug policy too. Thank you all.